Hello class, this is Celeste Mendez and I'll be covering settlement agreements. In my presentation, I will discuss the different type of settlement agreements and what a complete settlement should include. I will also be sharing my own settlement agreement that I drafted regarding the Samson and Emeralds catering event. So a settlement is an agreement or compromise between parties. It is a resolution that parties have agreed on without the need to go to trial with the opposing party. This is usually done when the defendant agrees to a resolution and the plaintiff then proceeds with dropping the suit. Settlements are generally made using either a release or a covenant not to sue agreement. This is then presented to the court and the case is then dismissed. It is important to understand the legal differences between the two types of settlement methods because the choice of method is influenced by the types of legal claims and the number of parties involved. So for settling a case, it involves the three basic steps, which are determining the case's settlement value, selling such assessment to the opposing side, and getting the client to agree on the settlement. So parties tend to settle and go through with the settlement agreement because it guarantees a resolution rather than having to go to court and not being sure what the outcome will be. 90% of civil cases filed in court tend to settle before trial, and most clients ultimately prefer settlement over the increased expenses of trial. As paralegals, we are not authorized to engage in the practice of law nor negotiate in a settlement agreement, but we may be asked one day to draft the settlement agreement for our supervising attorney, so it is important that we know how to draft one correctly. So there are two types of settlements. The first one is release, which is a complete discharge of all claims for liability between the parties signing the agreement. A plaintiff must never agree to release unless the plaintiff intends to terminate all present and future litigation, since someone wants to sign and pay for a settlement that's not either binding or final. A release is used only when there is a settlement of the entire lawsuit involving every claim and every party. Every good release should include a 1542 waiver, and that California Civil Code states a general release does not extend to claims that the creditor or releasing party does not know or suspect to exist in his or her favor at the time of executing the release, and if known, would have materially affected his or her settlement with the debtor or released party. So the second type of settlement is covenant not to sue. This one does not discharge any parties and includes a contract between two or more parties in which the plaintiff agrees to not sue or pursue an existing claim against one or more of the defendants. This is only used when there is partial settlement which does not involve every party. This settlement was first created to avoid the effect of the common law release rule, technically keeping the claims alive against the settling defendants as the plaintiff only agrees not to enforce the claims against that defendant. A defendant should never agree to a covenant not to sue unless the defendant has adequate protection against later contribution claims either by statute or by the settlement agreement. So here I have listed what should be included in a settlement. First one being stating whether the settlement is a release or a covenant not to sue, the names of the parties who are in the agreement, describing the events involved in the case. Next, the claims of liability, damages, and the defendant's denial of them. Specifying how pending court cases to be determined. And lastly, the agreement must be signed and dated by all parties and their attorneys. And in the next slide, I will be showing my own settlement agreement that I made regarding the Samsons and Emeralds catering. So here I have my settlement agreement that I drafted regarding Samson and Emeralds catering. You can see at the top I have the first item that shall be included in the settlement agreement, which is the type of settlement agreement this is. Mine here is a release agreement which discharges all claims and parties involved. Next, under recitals, I have listed the names of the parties, which are Benjamin and Sarah Sampson and Emerald's Catering. I then state the events which occurred, and that is Benjamin and Sarah Sampson filing a civil complaint for damages against Emerald's Catering for breach of contract. I then stated the damages that are being requested by the Sampsons, which are the excess of $25,000 in damages. In paragraph 3, I go more in depth of the damages being filed by the Sampsons. Here I have included that Emerald's Catering shall pay the settlement amounts of $25,000 within 30 days after satisfaction of the settlement to Benjamin and Sarah Sampson. So like I mentioned in the beginning of my presentation, every good settlement agreement shall include a waiver, and that waiver states under California Civil Code Section 1542, a general release does not extend to claims which the creditor does not know or suspect to exist in his or her favor at the time of executing the release, which, if known by him or her, must have materially affected his or her settlement with the debtor. Here I have the signature blocks, which should be dated and signed by both parties, including the plaintiffs and his or her attorneys, along with the defendant with his and her attorneys.